What's up, everybody? It's Jeremy Minnick with the Game Changing Roofer Podcast, a show created to share the stories of roofers who are changing the game in the roofing industry. This show is meant to help roofers build better businesses and better lives. My guest today grew up in the business, working firsthand in the construction industry prior to becoming an attorney. Now she is a board-certified construction law attorney focused on the representation of small and large commercial and specialty contractors throughout Texas. She is well-versed in lien and bond claim law, collecting for unpaid work, and defending against claims of improper workmanship. Here on the show today to shed light on the must-haves you need to put in your construction and restoration contracts and tell you how to avoid some of the most common collection issues is Karen Ensley of Ensley Benitez Law. Welcome to the show, Karen.
Thank you so much. I'm so happy to be here.
I'm really excited to have you here on the show. I think the topic that you've got today is, in the one sense, for maybe a lot of contractors and construction professionals, et cetera, potentially going to be, quote unquote, a little bit dense. We're going to really dive into the weeds of contracts, what it must have, that technical language. But dense as it may be, we're talking about something that's incredibly important to the health and the longevity of your business. Things that potentially, if you don't have these things in your contracts, could really come back to bite you in the long run and be incredibly negative. But before we kind of dive into all that, I would love to hear you unpack, how did you kind of get to where you are today as an attorney with the law firm that you're with the work that you've been doing, kind of related to leveling the playing field and things like that? Tell us a little bit about that journey and your story.
Sure. Well, I'm a non-traditional track kind of attorney. I had 2 years of college, took an 18-year break. During those 18 years, I did a lot of different things, but one of the things that I really, really enjoyed and was so important in my life is I went to work for my father, who was a general contractor. My dad built small retail and tract housing, apartment complexes, condos, churches, all kinds of things. And I knew about construction from being a kid growing up in a house where construction was talked about, but I really had the opportunity to learn construction in a different way. And I just loved contractors. I did, and I really enjoyed that job. And I transitioned from that job to my husband and I starting our own contracting company, which honestly wasn't nearly as much fun. But we did smaller retail stuff. We built custom homes, and I got the bug. I actually built spec homes in South Dakota, which is my fame. Yeah, pretty exciting stuff. So I had the opportunity to go back to college, and I did that, got my undergrad at 40, and I thought I was done because I had accomplished what I wanted to do, and that was not be a quitter and get college under my belt. And then I had the opportunity to go to law school, and it was wonderful, and it was scary, and it was really, really hard. It was really hard. And I went to Baylor. That's how I got to Texas. And good school, learned a lot, graduated from law school, got my bar card, stayed in Texas, and was fortunate to get a job with a law firm that specialized in construction. So at that point, I am joining my previous life with my new career. And I'm able to go back and work with the folks that I love and understand and be a help to them. And my first 12 years basically was working with commercial subcontractors, everything from dirt to roofing and everything in between. There wasn't just a trade that I didn't work with. And that was exciting and fun. And then in about 2015, I had a friend who got involved in the North Texas Roofing Contractors Association, which is just exactly what it sounds like. And she took me to a meeting, and I just got really excited about roofing, and I started learning about their challenges. And I've been able to develop an expertise helping storm restoration contractors that specialize in roofing. And so that's been really great. And I continue to learn. There's so much to know. It's very specialized. It's very different in many ways from straight up, contracting that doesn't have that element of insurance in it. So a year ago, my partner and I started our own firm, and here we are doing what we love with people that we enjoy, and happy to be here today to talk about it.
That's wonderful. I love the journey there. And I was joking around with Karen before the show about how she did what I couldn't, and that is make it through law school. That was something that I thought was going to be my path for a long time. I thought I was going to be partnering with my brother at his firm in North Carolina. And I told him, basically midway through college, I called him up one day and just said, look, just can't do it. I just don't think I can, kind of wear a suit every day. I don't think I can be in the courtroom every day. I don't think I can be doing that every day. And I certainly don't know if I can go to school for another 3 years. So not only did you, finish what you wanted to start in the 2 years of college and getting that degree, but just so impressive that you were able to go that extra mile. And just kind of curious, by the way, what led you to law school? I mean, what kind of was that jump in college that made you say, well, hey, this is maybe a path that I think I'd enjoy pursuing?
So really my desire to be an attorney started when my husband and I got married, and he had some legal issues he needed help with. And he had this really awesome attorney that was so wise and so kind and so helpful. And I thought, if I could ever be that person, that would be fabulous. And Perry Mason is a kid and all that stuff, right, too.
Right.
But, there's a certain, there's just so much reward from being able to have somebody bring you a problem and be able to help them solve it.
Right.
That sounds cheesy, but honestly, it brings me a lot of joy to do that. And that's really what got me interested in being an attorney. And I never thought that I would have the opportunity to realize that dream. And here I am.
Yeah.
Not wearing a suit, by the way, because my contracting clients don't care.
And I think, again, that's such an amazing, I'm sure you're right. If somebody said 20 years ago, where are you going to be in 20 years, right? That kind of thing. I mean, just unbelievable how those worlds united. And in some ways, it's just this beautiful full circle of you're kind of coming right back to where you started, your origin, where your heart is with contractors in the beginning. So as we transition here, I think, getting kind of rolling up our sleeves and kind of getting into the contract side of things. One of the things would love for you to unpack a little bit about is just sort of starting with some of the universal problems or most common mistakes, most common issues that you see with construction and restoration contracts.
So, we were talking earlier, there are some things that are universal to any contract, no matter whether you're a contractor or you're a dentist or whatever you might be. And those things are, you have to have clarity of terms. People need to understand what their obligations are and the consequences of not following through on those obligations. So that's big picture. A contract should actually say that it's a contract. Because believe it or not, there's actually case law that says calling something an agreement is not the same as calling it a contract, which I think is really weird. But so the parties need to understand that what they're doing is entering into a contractual relationship that requires them to fulfill obligations. Then when you move to the construction realm in general, and it'll be probably easier to talk about those things really specifically, but deciding who's going to pay what, how it's going to be paid, when it's going to be paid, what the job duties are, and what's going to happen if somebody gets behind on the schedule, or something doesn't happen. Where is that dispute going to be settled? How is it going to be settled? Who's going to get attorney's fees? Because, and let me just back up and say I'm a Texas attorney. I know a lot of stuff about Texas. I don't know a whole lot about any other states, and I'm not here to offer legal advice or tell anybody what the law is in Wisconsin or New Mexico or anywhere else. If you're not in Texas, you really need a construction attorney who understands what you do to help you, because construction is complicated and it's litigious, and a small mistake can cost you your business. So it's really, really important that you have good help. Every contractor needs a good construction attorney, a good insurance attorney who understands their business, and oh my gosh, and a CPA who understands construction. If your CPA doesn't know what a WIP schedule is, you have the wrong CPA.
Right, right. And
I never
before
have humble opinion. So,
and before kind of getting into too much of unpacking other problems related to the contracts, I do think it's important. Some people, listening to the show right now might be thinking, yes, I know all this, or this is reaffirming what I've been thinking about recently. But for those who are maybe thinking, well, how does this apply to me? Why would I need a construction lawyer? Or why do I need somebody in my corner for those things? What are some of the stories or examples you can share related to, you mentioned basically one mistake can cost you your business. What are some of those examples? What can you say in terms of that?
sure. I talked to a client this morning that didn't send out a proper notice before filing his lien. His lien is no good, and it's going to cost him $260,000 because he's going to have to take pennies on the dollar because he made the mistake of not understanding the lien process and not getting it done correctly. I have another client who's a very, very competent storm restoration contractor who decided to go into just regular general contracting and didn't know when you do work on a public project that there are bonds and you have to make a bond claim within a certain period of time in order to get paid. And that individual didn't send in a timely bond claim and has lost $85,000. So for some folks that are listening, $85,000 isn't very much, but for most of us, that's a lot of money. And by getting the right help and knowledge ahead of time, you can avoid that, which is, it's exciting to get a job and to do great work. But if you don't get paid at the end of it, that's not fabulous.
That's not very exciting. Yeah.
Yeah. Nothing exciting about doing free work unless you plan to do it ahead of time.
Right. Right.
Yeah.
And those are hugely costly mistakes. Have you ever seen anything even kind of beyond that? I'm just curious if, have there even been sort of stories beyond that where the results are maybe something that was a very small mistake, something seemingly innocuous sort of about the contract or the legal construct of the arrangement, et cetera, that was basically repeated over and over and over again. For example, maybe the contract that they sign with every client as they do every roof or every project, but basically there was a small, again, innocuous thing, seemingly innocuous, led to, again, huge problems kind of later on. Have you encountered those types of issues as well?
Sure. So let me tell you the story about my lawsuit over the placement of a comma. So literally we had this lawsuit and it really boiled down to where in one sentence of this 35-page contract, the comma was located. And it cost the client $365,000. So it shouldn't be that way, but my client negotiated the contract without my input and then brought it to me later when they couldn't get paid on it. And I did everything I could. The judge disagreed with my interpretation of that sentence and cost my client a lot of money. As to your question about common mistakes that get repeated over and over and over, mm-hmm. One of the most common mistakes that I've seen, and this relates to not just storm restoration, but anyone who sells services to a consumer. And there's a federal law. It's the 3-day right of cancellation. There are state laws. Most every state has a state law, and if not, the federal law is the default. And that law says that if you door knock, if you sell services to a consumer outside of your business, and you interrupt them in the middle of their lives and you get them to sign a contract, and you don't give them the 3-day right to cancel, your contract is void. Void as in void. Now, for most states, you can still get paid the reasonable value of the work if you do it, but you lose the benefit of all of the provisions that you so carefully constructed into your contract. The warranty and, just all the stuff we're going to talk about. You lose all of that because instead of having the 3-day right to cancel on the front of the contract, immediately adjacent to the signature block in minimum 10-point bold font, you stuck it on the back. And sticking it on the back is as good as not having it there at all. And folks that don't know that, it's just painful.
And, you know, as you're sharing these examples, I'm only thinking, I mean, what business owner for the most part in their right mind is catching those things? I mean, it's just, these are things that are so small, but so important. I mean, who in their right mind has that knowledge of that kind of the law, right? And the contracts. And so I'm sure that there are many people who are going to be listening and thinking, oh boy, you know, I better go check my contracts right now. They're looking through the page, they see it on the back, right? So this is excellent stuff. And as we progress forward, one of the things you had talked to me about was, you know, now that we can see that this is really important and how these little mistakes, or maybe not so little mistakes, obviously can be very, very costly. With that kind of understanding of mind of kind of the problem, you had told me a little bit about earlier that there are mainly two types of contracts. Just speak to that for a second, if you would, and just kind of unpack what's important about those kinds of contracts. And again, what are some of the things that contractors need to be looking out for, obviously, in those types?
Sure. So for most of the construction world, there are 2 or 3 different kinds of contracts, but most contractors use a lump sum contract. And that contract says, I'm going to do this list of work, and I'm going to do it for this amount of money. So I'm going to do all of these 47 things on my bid, and I'm going to do it for $250,000. That's a lump sum contract. There are contracts that are cost plus contracts. There are contracts that are, and cost plus is really just what it sounds like. It's the cost plus a percentage for overhead and profit. Then there's something called a guaranteed max, which is pretty esoteric, and we don't need to talk about that. But for roofing contractors, there's this handy dandy thing called a proceeds contract or a contingency contract. And that is unique to the, not just storm restoration, but fire, flood, anyone who's repairing damage to a property from a natural or not so natural event. And so these contingency contracts basically say that I, contractor, am going to do whatever the insurance company's scope is for the amount that insurance is going to pay. So at the time the contract is entered into, sometimes the parties don't even know, oftentimes they don't even know if the insurance company is going to accept the claim. And if they do, they don't know what that ultimate claim value is going to be or what the scope is going to be. And in Texas, a properly written contingency contract is enforceable. That's not necessarily true in other states. So again, contractors need to be making sure that they can do that in the state that they're in. But the important thing to understand about a contingency contract is, while it's enforceable, they're not necessarily favored by the courts, because as we talked about earlier, the important thing about a contract is that the terms are understood and agreed upon, and that anybody can look at that contract and know what the duties are of the parties to the contract. So when you sign a contract that says, I, the owner, am going to pay you whatever amount of money I get, and you, contractor, are going to do whatever this scope ends up being, that's really much harder to enforce.
Right. And
so what I always recommend to my clients is certainly get those contracts signed. Doesn't hurt a thing at all. They're enforceable. They're enforceable because the parties, while they don't know what the terms are, they've agreed on how those terms are going to be determined, and that makes it enforceable because it's specific enough to be enforceable. But a prudent contractor is going to want, as soon as they have a defined scope and price, they're going to want to issue an addendum to that contract that specifically identifies, now we know what's going to be done, and now we know how much you're going to pay me. So let's sign this extra little piece of paper so that we're all on the same page and there's no confusion.
And from your experience, how often do you feel like that seems like an important sort of next step in the process contractually? How often do you feel like that addendum is being put in place?
It's not widely used. I think because it brings clarity, and one of the things, and it's because a lot of homeowners, well, homeowners are not sophisticated users of construction services, right?
Mhm.
I mean, they're homeowners, they have their day job, whatever that day job might be. They're not in the construction business, they're not in the business of reading contracts. And so they have oftentimes misunderstandings or lack of understanding about just what they're agreeing to. And that doesn't mean the contract's unenforceable, but it can cause problems and hard feelings and lead to payment problems because the owner thinks they're getting screwed over, or that they're being taken advantage of, or that the contractor's lying to them, or they didn't understand it. They didn't think they'd actually signed a contract. I hear so many times owners tell me, I thought I was just signing something that let them go up and look at my roof. I didn't realize I was signing a contract that obligated me to let them do the work.
Gotcha.
And to avoid that confusion as soon as possible, well, I don't always believe when somebody tells me that.
Right.
But nonetheless,
Right.
These addendums that should be used, I think, I don't think there's a scenario where I would say don't bother.
Right.
I think they're just helpful.
Right. Right. Well, that's excellent. And those are, yeah, I mean, just incredibly insightful points about the contracts. One other thing that you were talking to me a little bit about before the show is this idea of potentially just, and this is kind of maybe a nice sort of a quick summary. We can also talk a little bit specifically about insurance and restoration related contracts. You've already talked some about that, but in a little bit of a more general sense for a quick moment, you talked to me a little bit about the must-haves of a contract versus maybe the nice to haves, or the what you want in a contract, but maybe it's not necessary. Can you outline both of those and obviously just unpack? So what are some of the must-haves in these kinds of contracts?
So a must-have is anything that's required by statute. So, you have to have a price and a scope. You need to have a place where a date. I mean, we're going to get really, really basic.
Yeah.
The names of the parties, the date of the contract, a price and a scope, and an owner's acknowledgement that they are obligated to pay. So those are the very most basic components of a contract. From there, different states have different statutory requirements for what has to be in a contract. We talked about the 3-day right of cancellation. That only applies for door knocking, but some of my clients put it in anyway because they just don't want to have the fight. And their philosophy, which I can endorse, I think, is that if somebody doesn't want to do business with me, I'm going to let them go. I'm not going to force them into a contract. That isn't always the case, because you may have done a boatload of work to get to the point where, the contract has been signed. You may have spent hours and hours on this claim, and you may have estimated it up one side and down the other, and you're not willing to walk away from that. And I don't have a dispute with that either.
Right.
But 3-day right of cancellation is required. In Texas, a law was just passed where there now has to be a disclosure in the contract that the owner's required to pay their deductible. That's new since September. Has to be 12-point bold font. It doesn't matter where it's in, but so things like that, and things, consumer warnings, and you may lose your property. So there are statutory requirements for every state for contracts that have to be in.
Right. And I'm assuming, maybe we don't need to share the numbers and things like that, but I'm sure you've worked on a lot of contracts. I'm sure you've seen a lot of contracts, cross over your desk. How many of these must-haves or even nice-to-haves would you say, and how often are these missed? Just generally speaking, percentage-wise, how often are these kinds of things missed in contracts?
So probably 90% of the contracts I see are missing at least one must-have.
That's not very good. I don't think.
That's not good at all.
Sounds like a big problem. Yeah. And one of the things too, I think this is just a good pivot. We'll talk about this at the end of the show, but as a resource to those looking for proper kinds of contracts, where can somebody go? I think that you have a website where you keep a lot of those things. Maybe you can speak about that website along with, just quickly, what are some of the other resources or what to look for, maybe even in a construction law attorney. It's like, where should people go? Where should contractors go to find these resources or to find the right people to help them? What should they be looking for?
Sure. So I, along with Steve Patrick, who owns Level the Playing Field, or he's one of the owners of Level the Playing Field, we wrote a package contract documents that are specifically for storm restoration contractors, and it's called Contractor Pro Docs. Contractorprodocs.com is the website. It's, I don't know, 30 different documents that someone who just wants to know that they have all their bases covered, it's a good way to go. It has a little bit of a different kind of a contract construct. It's kind of a Jack and a Jill. It's a service agreement that when the roof is bought, it requires the owner to sign a contract, a construction contract. So, if somebody's interested in contract documents, that's a good place to go. What I see a lot is attorneys who are very good construction attorneys but don't really know about storm restoration, or somebody who's a real estate attorney but doesn't really know about construction. It can be really challenging to find an attorney who understands your business. So certainly a construction lawyer is a good place to start. Most states, I think all states, have associations, roofing associations. I think that's a great place to go to find a lawyer, because anyone who's committed enough to be part of that association hopefully has spent the time to really educate him or herself about the needs of that client base.
Right.
And if not, material suppliers a lot of times have relationships that they've developed, and they have relationships, with attorneys and relationships with other contractors. And that's another way to find an attorney, but it can be tough.
Right.
Yeah.
Those are great resources. Obviously, that website, contractorprodocs.com, along with, I just love the advice that you just gave, which is, look, there might be a lot of construction attorneys out there, or, enough, kind of in your area that you could go and work with and find, but it's definitely worth, like almost any buying process, find someone who's maybe just that extra level or all the way a specialist in insurance work, especially if that's something that you're doing, or see if they're willing, maybe you're, especially if you're a company that's doing a ton of this kind of work, you might be running into that pretty frequently and needing them to be looking over contracts frequently and regularly, et cetera. So obviously I think there's a lot of construction attorneys out there who would be open to that conversation, where even if they don't know about this type of work, they might go, well, that sounds pretty interesting. Tell me more about that kind of work. Are there other people like yourself, other roofers out there who need this help? And I'm sure the answer would be yes, right? There's lots of roofers, lots of companies getting into restoration. What I'd like to turn to next is another topic that you had talked about, which is kind of common collection issues. So again, as we did with contracts, when it comes to common collection issues, maybe what are some of the most common examples or problems that you see? What do you see frequently happening?
Do you mind if we just back up and talk a little
Absolutely.
bit? I'm sorry.
Absolutely. Yeah.
Some not have tos, but some really important things that every contract should have. And I won't belabor these, but every contractor should have in their contract the right to supplement the claim, because that's really important. Claims are often undervalued by the insurance company, maybe on purpose, maybe not. But the owner needs to give the contractor permission to supplement the claims and to cooperate in that process. Overhead and profit is a giant issue with storm restoration. And there needs to be an acknowledgement that the contractor is a general contractor and therefore entitled to overhead and profit. That's very important. Authorization to contact the adjuster to discuss price and scope. Most all states allow interaction with the adjuster and the contractor to talk about price and scope, but it needs to be in the contract, because the owner has to give permission in order for the adjuster to be able to speak. Change orders. I'm a big fan of a provision in the contract that says, if you ask me to do something, whether or not it's reduced to writing, you're going to have to pay for it, because there's, disputes over change orders. is one of the most common disputes there are in construction. That is certainly true of non-restoration contractors, but it's true of restoration contractors as well. Exclusions, make sure that your contract says I'm not going to be responsible for gas lines within 3 inches or 6 inches of the underneath of the deck or whatever the case may be. Roof sags, damage by other contractors, nail pops, damage to, you know, shrubbery or whatever. You need to set forth in the contract what you are and are not going to be responsible for. Mold is a big thing. You know, if somebody finds mold, who's responsible for that? Assignment of benefits and assignment of claims is a hot topic across the nation. In Texas, there's no such thing. In Florida, I think they've basically phased that out. But in a lot of states, an owner has the right to assign their benefits and their claim to the contractor. And if that's the case, it needs to be very carefully written to comply with the statute. And so that's, you know, whether that's a separate document or whether that's inside the contract, that's really important. Warranties, and we talked a little bit about that, but I'm a big believer that the owner is not entitled to a warranty until the contractor's been paid in full. And then, is the warranty transferable? Is it not transferable? Personally, I'm not a fan of transferable warranties, because part of agreeing to provide someone a warranty is you vetted that customer and you agreed that you're going to work with that customer, and now that warranty is transferred to a stranger, and that stranger could be crazy, unrealistic, whatever the case may be, right?
Right.
Arbitration or litigation is a big, big thing. And I always tell my clients, if it's you versus a homeowner, you do not want to be in court, because that jury, half of them maybe have been homeowners, but none of them likely have been a contractor. Right. And they're just a bias. Right. So you want to make sure that you are, that you're in arbitration whenever possible. And there are statutory requirements for enforceability of arbitration agreements. You want to waive a jury trial. Attorney's fees and interest. I think you should always have the attorney's fees and interest clearly spelled out in the contract, because in some states, if it's not in the contract, you don't get it. In Texas, for some reason, you can get it against an individual or a corporation, but you can't get it against an LLC or an LTD or anything else unless it's in the contract. So it's really important, because unfortunately, litigation is very expensive. And there's nothing worse than at the end of that process to find out that you won, but it cost you so much to win that you really didn't win anything at the end of the day, because those fees are not recoverable, and that's just a shame. Right to stop work if not being paid, right to repair work, and then advertising, the right to advertise, right to take pictures, right, is really helpful. And then, yeah, all the disclaimers and all that stuff. So sorry, I just had to get that.
No, that is excellent. And I think, again, this is one of those where those points, by the way, just to confirm by way of summary, are those must-haves in a contract, or are those maybe not absolutely necessary, but you should have these in there to cover all your bases?
Okay, so those are Karen's must-haves. They don't affect the enforceability of an agreement. Right. But they greatly affect the contractor's rights under the agreement and are super helpful.
Right. Right. Great. But nevertheless, it's one of those where I'm really glad that you went through that list, because at the end of the day, one, I mean, sure, it's a bullet point list. It's lengthy. These are all kinds of things that maybe contractors, and again, people listening to the show are thinking, oh, that's in there. Oh, but wait, that's not in there, and that's not in there, and that's not in there. I mean, these are the things that are so easily missed. And it's kind of one of those, I mean, law is this way, right? Where, you know, these are the things you never think about until there's a problem. Yep. And usually that problem is painful and it hurts. It hurts a lot, whether it be related to money that you didn't get paid or won't get paid, or time, right? Because that's another sort of silent killer potentially within all of this, is just that the disputes that might arise with the homeowner or the insurance company, or through litigation. I mean, the time that can be kind of sucked up or robbed from you. and having to deal with all this is also costing you money and opportunity and all these different things. And beyond all that, unless you're incredibly stable with your stress levels, these are not the kinds of things that you want to be dealing with on a day in, day out basis.
Very, very stressful, very emotionally draining, very time consuming. And, sometimes a contractor has to choose, do I want to spend my time chasing that money, or do I want to put my time toward, moving the business forward? And because there are only so many hours in a day, and there are only so many resources that a company has.
Right.
Well, in people or time and treasure. So,
right.
So yeah, avoiding, and by the time you realize there's a problem, it's generally too late to fix it. And so getting that in the contract ahead of time is so important.
Right.
Such a small thing, such a seemingly small thing that can have such a huge consequence.
Exactly. So excellent. I'm really glad again we unpacked that. And again, just pivoting quickly more into common collection issues. Unpack that for us just a bit. What are some of the most common, collection issues? What are some of these things that arise, pain points, problems, et cetera? What should contractors be thinking of or keeping an eye out for there?
Sure. So not signing up with crazy is super important. I just can't stress enough that you, the contractor, are in many ways a bank. You're paying your labor and you're putting out your materials, whether or not you ever get paid. That's just the reality of construction.
Right.
And so you want to make sure that you're dealing with someone that's likely to pay your bills. And that's just, I can't stress that enough, because so many people are just happy to have a contract signed.
Right.
And then they'll come back and say, I just knew I shouldn't have done that when I did. I just, I had such a bad feeling about that contract. Or, with a commercial contractor, that contractor, I had heard rumors that they were in financial trouble.
Right.
Or this was 5 times bigger than a job that this general contractor had ever done, and I just knew I shouldn't have done it, and I did it anyway.
Right.
When your gut tells you something, it's probably right, and you want to listen to it. But beyond that, setting the client's expectations right from the beginning, that this is a business relationship. Here's what I'm going to do. Here's what you're going to do. And that when I do this build, or, this is a build that's going to go over the course of 3 months, I'm going to come to you every 30 days and I'm going to expect you to write me a check. We need to be able to do that. Are we going to have a problem with that? And just being really frank and having that conversation and setting that expectation early. I also think it's a good idea, and it sounds kind of funny, but you need to toot your horn a little bit. And the owner of the property doesn't have any idea what you're doing. They don't have any idea how hard it is. They don't have any idea what goes into doing that work. And so they don't really appreciate it, because you make it look easy because you're really good at it, right? And it just looks seamless. And you just show up, and in the morning they take off the shingles, and by afternoon there's a whole new roof, and it's just like magic.
Right.
And they don't see all of that effort. And if you don't let them know what value you're giving them, they're less inclined to want to pay you for it. And it seems funny, but I think there's really something about that.
Right. It's interesting, as you mentioned that point, related back to your list of, we'll call it again, Karen's must-haves, right? But in any case, very important to have, or very important to consider having on your contract. That list that you ran through, that is something that I think, while nobody likes a contract that is incredibly hard to understand and basically just like impossible to understand. I mean, nobody likes that, although some aspects of that are necessary, right, to be legally sound. My main point is just that can show professionalism. Having a contract that has all the I's dotted, all the T's crossed, you've covered every single one of your bases, can demonstrate that professionalism. In other words, if the homeowner is wondering, what's this contractor doing for me? I mean, what is the value of their providing? I mean, number one, what you just mentioned is that contractors can make it look easy. They're so good at what they do. They show up in one day, boom, they're gone. Right? Homeowner might be thinking, well, what's he done for me? But I think one thing that is can be appreciated by the homeowner is through a contract, you're showcasing to them, look, this actually requires a lot of risk on our part as well. I mean, this is a big project, a big investment related to your home. And so that is something that you're paying for, is that professionalism. And also, in a sense, like those warranties, those are things that the homeowner or the insurer is paying for. And obviously, I'm sure you've seen that time and time again, but that was just something that really jumped out to me. And maybe just quickly, have you heard any stories or seen ways in which homeowners or even just insurance companies or other things like that have been impressed by some of the contracts that you've helped put together, or just contracts in general that are really well designed? I mean, have you seen that kind of almost even help to make an impact in the professionalism of the company?
Oh, I think so. I think a professional presentation and a professional looking contract by somebody who's, clean, neat, has a logoed shirt on, has, something on the side of their truck, they have a business card. All of that says, I'm a professional person and I'm going to provide you with professional services. And, while the homeowner may or may not understand everything in a contract, although a contract should be written in a way that anybody with an 8th grade education can read it if they want to. Most people
Right.
just simply see that many words and they're just like, I'll never understand this, so I'm not going to read it. But insurance companies certainly do understand
Right.
what a professional looking contract is. And I think they do take that more seriously. And when they see that it has terms in there that are enforceable, they are, I think, less inclined to fight with the contractor. Having a professional website,
Right.
professional marketing materials, all of those things goes into a presentation that lets that customer know that you take your business seriously and you expect them to take it seriously as well.
Right. And wow, that's fascinating, because another thing that comes to mind for me is almost the psychology, both in the mind of the person at the insurance company or even in the mind of the homeowner, that, right, this idea that if the contract looks disheveled or so simple that it's not even saying anything, that is communicating something to the homeowner or the insurer. It's communicating exactly what it's described. It either looks disheveled or that this doesn't even seem like it's legitimate. But a contract that's obviously nicely put together and also covers all the bases, number one, to the insurer, as you just mentioned, makes them probably less likely to fight with you about what's owed, right? There's more of a professional setting there. Hey, look, I can see that you know what you're doing. You've got to respect also for what we're doing in insurance and in our legal contracts, et cetera. Let's work with this company and let's figure out, obviously the fair claim. And in the case of the homeowner, I feel like some of those horror stories of homeowners taking the check, running or foolishly spending it before, they needed it for X, Y, and Z, often just stem from a lack of communication, which isn't just contractually, but it's related to it. So in other words, when, you're getting them to sign or right after they sign, making sure that they understand the contract, understand the insurance process, how the checks will be coming in, and those kinds of things. And just briefly, I would love for you to speak to how important, obviously the answer is going to be vary, but how important is it that the homeowner is educated on this insurance process? And what are some of your best tips or strategies or suggestions on how the homeowner can be educated on the insurance process?
Sure. Well, it is so important. It's so, I cannot stress how important it is for them to understand the insurance process. Most homeowners, especially, business owners too, but most homeowners maybe they've had a little car wreck, or, maybe they've had, most everyone's had a little bit of a car wreck.
Right.
So they understand the process of, I had to get my car fixed. But having your home repaired is so much more complex and so much more difficult typically than something like that. It's not just dropping your car off somewhere and it's magically fixed and you pick it up later and you never pay a deductible and you don't have to worry about it. So understanding the dynamic between the insurance company and the insured and the contractor, and who has what duties in this process, and understanding that an insurance company, they're not the devil, they're not, but they're a business that's in the business of making money, not in the business of overpaying claims. And they're going to have a different perspective about what needs to be fixed. And, Steve will talk about piecemealed roofs, right? And if an insurance company can replace, one side of the house or, 10 tiles on a roof, that's all they're going to do.
Right.
And the homeowner needs to understand that the contractor and the homeowner are aligned in wanting that property properly repaired, because the contractor has to warrant that work.
Right.
And so most owners just don't understand that. And when you explain it to them, in simple terms, and you give them some examples, it's easier for them to understand. And then they want to work with the contractor to make sure that their home is properly repaired. So
Right.
it's super important. And, the first thing we sell is ourselves, because we're service professionals. I'm a service professional, a contractor, as you are.
Right.
And then we sell our product. And until somebody believes in me, they don't want to hear anything about what I have to say.
Right. Right.
And that's true of contractors as well.
Right. One word that stuck out there, I don't know if you actually said it explicitly, but as Steve Patrick said on the show that I did with him, the P word, profit. He said, at the end of the day, the insurance company really does, as you said, they're all out to get everybody. Not everybody that works in insurance is out to get everybody, but they're a business, and their business, like everybody else's should be focused on making a profit. Sure. So they're certainly focused on making a profit. And just hearkening back quickly to one of the things you outlined in sort of this would be really good to have in your contract was you mentioned the words profit and loss. And you also spoke about a concept that I believe if I'm accurately kind of summarizing this, that if you're not a GC or general contractor, you won't be able to kind of most fully request or put forward your claim for profit and loss. Can you kind of unpack that strategy and what does that look like in a contract?
Yeah, so it's profit and overhead. And overhead is that's okay.
Of course.
Yeah. So overhead is your
right.
that it costs you to be
right.
in the business.
Right.
And profit is
P&L statements are important too, but profit and overhead is what we're after right now.
Profit and overhead. So what a lot of homeowners don't know, what a lot of people don't know is when I pay my mortgage payment every month, I'm paying a mortgage payment, I'm paying my taxes, and I'm paying my insurance. And when I pay my insurance premium, that insurance premium includes overhead and profit built into it. So the property owner is paying premium based on overhead and profit being paid for repair work. But what the insurance companies have said over the years is that if you're not a general contractor, then you're not entitled to overhead and profit. They'll say, the project isn't complex enough, there aren't enough trades. We'll pay overhead and profit for the gutters and the screens, but we won't pay it for the roof because you're a roofing contractor. And none of that is true, and none of that is a legitimate basis for refusing to pay profit and overhead. Profit and overhead is owed under the policy because it's not excluded under the policy. Now, that's not necessarily universally true for all 50 states. Let me just say that, but generally speaking, that's a true statement. And it's a big, big fight because it's 20% plus of a claim. Right. And if the insurance company can save 20% on every claim, they're going to have very happy shareholders.
Right. Right. I mean, that's huge, right? As on the contractor side, the difference of 20% being, well, you either basically did the work almost close to that cost, right? Or you made a profit. And so how important that is. The kind of returning to this idea of kind of common collection issues, you also unpacked an idea earlier of contractors must understand that insurance companies basically generates the payment and how that process works. Can you kind of unpack what you meant by contractors must understand that the insurance company generates the payments, and also unpack sort of getting deductibles paid early and getting materials paid for quickly? What are the strategies that you were referencing there?
Sure. So the unique thing about storm restoration work is the insurance company is paying for the work to be performed, with the exception of upgrades and that sort of thing. Primarily, the insurance company is paying for the contractor's work, but there's no contract between the insurance company and the contractor. So the insurance company pays the owner, who they're insured, which is what their contractual obligation is. And then the owner has to pay the contractor. And if the owner interrupts that process and holds on to that money, it's hugely problematic for the contractor.
Right.
So I don't know, I would be interested if anyone has ever gotten an insurance company to pay directly. Sometimes that happens with preferred contractors or preferred vendors.
Right.
Matsky or whatever. Sometimes there are relationships where the insurance company pays the contractor directly, but for the most part, it just never happens. They don't, my contracts always say, I can be paid directly, I contractor can be paid directly, I contractor can be paid with a joint check. I've never seen it happen.
Right.
So the owner has to pay the contractor the money that it gets from the insurance company. So what I recommend is, as soon as possible, certainly by the time the insurance company has acknowledged that there's a legitimate claim that has been opened, the contractor needs to collect the deductible. It needs to be collected in a separate check, not as part of the ACV. That's important in Texas because in Texas, the contractor is required to collect the deductible. You have to show that you collected it in order for depreciation to be released. So it really should be a separate check, and it should happen very early. And the reason why I say that is many reasons, but I like the owner to get into the habit of paying the contractor.
Right.
Right. And if you wait till the end of the job when all the work is done, which some of my clients still do, amazingly, what happens if, maybe they had all the best intentions in the world of paying.
Right.
Something happens, their kid gets sick, their truck breaks, they lose their job.
Right.
What's going to happen, right? So you get the deductible as soon as you can, as soon as it's reasonably practical. Now, you set that money aside. You don't spend it on anything else, right? I mean,
right.
We're not taking checks and running off with them. But we're getting paid early.
Right.
You can get that deductible. And then I recommend before the work starts, preferably at least 24 hours, to get a material draw.
Yeah.
Because again, you're getting the owner in the habit of paying. Now the ACV check can be anywhere from, 70% plus of the total base claim. You can get the ACV check, that's fine, but you want to make sure your materials are covered, because you are going to pay for those materials whether or not you ever get paid by the owner, because I've seen a lot of lawsuits against my clients from material suppliers, and they don't care, they're going to get paid.
Right.
And then you want to get, the day after, the afternoon of, or the day after the work is completed, that salesperson should be out there walking the job, making sure the owner's happy, that everything that needed to get done got done, that the yard's cleaned up, etc. And then as soon after that, if possible, you want to be picking up that final check.
Excellent. So great. That's obviously really important there in terms of that idea, kind of almost training the homeowner on making those payments, getting consistently into that habit, especially early on in the process. And so another thing that I think that brings up is maybe the idea of supplementing as well as picking up supplement checks. So unpack that process for us and why that's so important and kind of what that looks like.
Sure. Well, I think I talked a little bit about the fact that I'm a big believer in supplements, and I'm a big believer in supplement companies. I think they add great value to the contracting community for storm restoration contractors. Identifying damage can be very, very technical, and it's time consuming. And so whether that's done internally or whether that's done with an external company, I think checking every insurance company Xactimate and making sure that it is comprehensive is really, really important. Explaining that process to the owner is very important, and then letting them know when you're going to send in a supplement request and making sure they're copied on that, because there's nothing worse than a supplement being issued. The owner didn't know it was happening, thought they got an extra check, and thought they had found money, and now they're going to take the kids out to the water park this weekend or something, because they don't realize that's the contractor's money.
Right.
And so it's really important to educate the homeowner about that process and to make sure that you're communicating along the way and copying the homeowner with the request. And then, hopefully the insurance adjuster is letting the contractor know when those payments are being released so that they can be retrieved from the homeowner. Very important.
Right. That's excellent. And again, just in your experience with working with so many contractors, I mean, how many people are missing this piece of the process, or how many are maybe not doing it as thoroughly as they should be? And again, kind of what are the consequences, but also the benefit of doing this right? You know, why supplement? Why collect these checks? Why be so consistent about it? Why is that so important?
Well, it can make a 20 or 30 or 40 or 50% difference on the claim value.
Mm-hmm.
It can, I mean, I have heard some really, really high numbers of increased recovery for supplementing. Now, obviously, we never supplement for things that we didn't do.
Right.
We never supplement for things that are not legitimate. I'm not a fan of that. We are business people who have integrity, and we don't do that.
Right.
If something is legitimately part of the claim and should be covered, then the contractor needs to pursue that, and they may need the homeowner's help in pursuing that, because we want to make sure that we stay as a contractor and we don't cross any lines, that are going to get us in trouble with any of the laws of our states about public adjusting or any of that stuff. Right. So we want to do what we do, and we want to be experts in what we're doing. Most contractors don't supplement correctly, and it costs them money.
Right.
Most. That's
right.
just reality. It takes a little bit longer, and but it's worth the effort. And having somebody in your corner that can walk you through that process, whether it's internally or externally, is a huge benefit. And I'm just a big fan.
Right. Right. Well, that makes great sense. And as we kind of reach the final stretch here, just in terms of obviously this important idea of contracts, what needs to be in them, and also why it's so important that you walk the homeowner through the process, that they really understand, especially in the realm of insurance, what is happening. Are there any other things, any other final topics, points, obviously, Karen, that you want to touch on that you feel like contractors really need to hear as it relates to all of this?
Sure. So now we get to the bad news part. So what happens if you don't pay, and you've done everything you can do to get the owner to pay, and they're just not going to do it? What are you going to do? So as the contractor, you have basically 3-4 options. Filing a lien, if your state allows that. You want to get a lien against the property. You want to get a clout on that title. It may not get you paid today or tomorrow, but hopefully it gets you paid somewhere down the road. And liens is really a whole process and a whole nother topic. But filing a lien, sending a demand letter. Interestingly, so many of my clients, when I say, can you send me a copy of your final invoice? Well, I didn't send one. Well, if you don't send a final invoice, how does the owner know what they owe you, right?
Right.
So getting that final invoice, sending a demand letter, filing a lien. I send a lot of demand letters on behalf of my clients who are not getting paid by the insureds. And I have about a 50% success rate, because sometimes they just want to know that you're serious enough to hire an attorney, and most people don't want to deal with attorneys.
Right.
So attorney demand letters can be helpful. Sometimes somebody wants to pay, but they can't right now. Get them to sign a promissory note so that they're committed, and they admit that they owe it, and they're committed to payment. It's much easier to collect on a promissory note than it is on a construction contract.
Gotcha.
And you can charge interest if you want to. You don't have to, but discounts in exchange for immediate payment. Sometimes the reality is that 75% today is going to be vastly better than 100% a year and a half from now.
Right.
Collection agents, some are good, some are not so good. You're going to give up 20% to 40%, but 60% of something is better than 100% of nothing.
Right.
So you find a good collection agent and they'll work with you. That's great. If all else fails, there's filing a lawsuit.
Right.
Before you file a lawsuit, I'm always going to ask you, did you do the work? Is there any dispute about the quality of your work? And is there any hope of collecting? Because it doesn't matter how great your case is. If you can't get the money after the lawsuit, then you've spent more money chasing money you're never going to get.
Right.
So lawsuits can be really helpful, and we file a lot of them. And I'm a big fan of lawsuits, but
right.
but only in the right circumstances, and only for a contractor who has the emotional and psychological and financial stability to get through that process, because it is grueling.
Right. Right. And not that it's, again, like overly expensive, but it is expensive. I mean, there's an actual cost incurred for someone like yourself and the help of that, but also, again, just the time, the energy, the resources. I mean, it's just an exhausting process. And I think maybe this is maybe not what everyone thinks, but certainly I think it's common to think, well, a lawsuit, how long is that really going to take to kind of collect? I mean, I think the answer is most of the time, like, it could take a long time.
It can take a long time. And that's one of the reasons why I used to really not be a fan of arbitration.
Right.
But because of a lot of reasons. But and especially now with this whole COVID thing, everything is on hold. The legal system is on hold. And it's just now starting to open up a little bit. And I know, back east, everything is still just on lockdown.
Right.
Left coast, right coast, everything is. So arbitration, while it's a little more expensive on the front end to get it started, almost always is going to go much more quickly. And it's going to be less expensive overall, because while you're paying for the arbitrator's time, there's not a lot of gamesmanship that's allowed to occur. You're presenting your case to an attorney who understands your business, understands construction, and can make a decision quickly. You don't have a year and a half of continuation after continuation after continuation.
Right.
It's very common here in Texas, especially in some of the larger counties, to wait 2+ years to get to court, because the courts are just so backed up.
Right.
And with arbitration, you don't get that. It's a more streamlined process. And for that reason, especially for contractors, I'm
right. Well, this has been amazing. We've covered a ton of ground as it relates to kind of the must-haves and also the really important to haves in a contract. We've talked about basically the idea of common collection issues and how those can be circumnavigated. And we've also talked a lot about supplements, payments, and everything in between. I mean, you have shared a ton of knowledge and detail, and it's amazing too, again, just to see, related to your story back at the beginning, Karen, you've come full circle in that this is the industry you grew up in. You have a great love and a great spot, soft spot in your heart for contractors. So thank you again for everything that you've shared on the show today. And if contractors want to, potentially, if they're in Texas, they want to work with you, if they want to learn more about you, if they want to learn more about the resources and the programs and the trainings that you put out there, or connect with you in general, where can they go to learn more or connect with you?
Sure. Well, my cell phone always works, 817-538-6894. Go on my website. My email address is karen@eblawtexas.com. And love to talk to you if you're in Texas. Love to talk to you if you're not in Texas. If you have a question and I can spend a few minutes talking to you, I'm happy to do that.
Excellent. Excellent. Well, thank you so much, Karen, for your time, and thanks for being on the show.
Yes, thank you. It's a pleasure.